But those who devised the rules of court chose to extend the prohibition to all kinds of actions, whether civil, criminal, or administrative, filed against parents and other direct ascendants or descendants. The disqualification is intended to preserve family solidarity and to prevent a common child to be used by a parent against the other on criminal litigations between them. The solidarity and unity of the family is shattered when a child takes sides in parental feuds. Neutrality is still the best part of prudence on the part of descendants, except only in extreme cases. Thus, on account of the foregoing reasoning, this court cannot issue subpoena to Respondent Chief Justice children Carla R. Corona Castillo and Francis R. Corona. With respect to the request for subpoena duces tecum and ad testificandum to Mr. Constantino T. Castillo III and Charina R. Corona, this court adopts the doctrine of necessary implication. The doctrine of necessary implication means that what is implied in the statute is as much as part thereof as that is expressed. This court believes that by necessary implication, children-in-law are covered by the prohibition to testify on account of parental and filial privilege. The ratiocination of this court is bolstered taking into account the primordial purpose of parental and filial privilege, which is the solidarity and unity of the family. Wherefore, in view of all the foregoing, the request for the issuance of subpoena dated January 12, 2012 be denied for lack of merit. Signed, Senate President Juan Ponce Enrile.
Counsel may proceed to your state this additional argument. If yes.
I made, Your Honor, Mr. President, I made that short manifestation because I was not yet informed that there is a decision forthcoming. And aside from that, there was a categorical statement that there seemed to be no opposition. It is only for that purpose, Your Honor, that we wanted the records to speak the truth of the reality. Thank you very much, Your Honor.
Mr. Senate President, Your Honors, please.
What's the pleasure of the Chief Counsel of the House of Representatives?
Mr. Senate President, with all due respect, may we request that the prosecution be given time to file a written motion for reconsideration, Your Honors.
You may, but I would like to advance to you that your request called for a compulsory process, subpoena testificandum and subpoena duces tecum, to compel the appearance of certain persons to appear here and bring documents for the purpose of making them testify for the prosecution. And I think that since they're the principal party in this case is the Chief Justice and he's the respondent, and the people being called upon along with him to be brought here under a compulsory process to testify would expose him to a possible questions that would compel him to testify against himself. That's the reason why this court has rendered the decision denying the request of the prosecution.
In that case,
it is true that in proper situations and circumstances, a person may invoke the right of not to be compelled to testify against himself when he is sitting on the witness stand. But in those cases, a compulsory process has not been issued to him. And if I remember my Constitution, the Bill of Rights, and the criminal procedure that I learned, the only one entitled to compulsory process to compel the attendance of witnesses in his defense and evidence for his defense is a person charged with a crime. This proceeding is akin to a criminal case. And so therefore, that is the basis of the ruling of this impeachment court.
Mr. Senate President, with that, the prosecution submits to the ruling of the Senate President.
Thank you.
Thank you.
Mr. President. Mr. Presiding Officer.
The gentleman from Taguig.
Mr. Presiding Officer, I agree with the ruling as so far as the Chief Justice is concerned. But as to the wife, the children, and the son-in-law, may I put on record my reservations, Mr. President. First of all, Mr. President, I'm also a family man. And whether or not we should call the children is really not my concern, but actually the concern of the prosecution. But I'd just like to deal with the strict legalities or to deal with the interpretation of the law, whether or not the prosecution is in fact entitled to subpoena the children and certain documents. First of all, Your Honor, the relevance and materiality of the subpoena sought is readily discernible from the documents so far as disclosed by the prosecution in their pleadings. Among the charges against the Chief Justice is the accumulation of ill-gotten wealth, the alleged accumulation of ill-gotten wealth, and false entries in the SALN. Some of the properties discovered by the prosecution allegedly are in the names of Corona's children. If you look at Republic Act 1379 on forfeiture of ill-gotten wealth, paragraph 1 states property unlawfully acquired by the respondent, but its ownership is concealed by its recorded in the name of or held by the respondent's spouse, ascendants, descendants, relatives, or any other person. Clearly, it is relevant and material, and clearly the law points us to the fact that these people may be called if the allegations is that these properties were hidden and their names were used. Clearly, legitimate inquiry on properties extend to respondent's spouse, ascendants, descendants, relatives, or any other person, especially in this case where, for example, alleged TCT number 2039-P issued on 23 October 2008 in the name of one of the daughters was issued for 6 million pesos, a property in Taguig where when she was only 30 years old. And it was Corona himself who was acted as her attorney in fact. The question, Your Honor, is may they claim disqualification or privilege not to testify against the respondent in the impeachment trial? It really depends on the purpose and the offer of evidence. But we are not yet there, Mr. President. In any event, the time to invoke this is when they are called to testify. A subpoena cannot be defeated on mere invocation since it would be premature until they are actually called to testify. Some may say this mere semantics, meaning i-issue po natin na subpoena, tapos pagdating dito, hindi rin pala pwede mag-testify. But this court cannot shortcut the process. We cannot deny the subpoena because we cannot predict if and when the daughters will in fact manifest or claim the privilege, or if the husband will claim the disqualification against the wife. The proper procedure is for us to issue the subpoena and for the defense or the witnesses to be the one to claim the privilege later on. But moving ahead of ourselves, Your Honor, even assuming that there is such a privilege, and there is such a privilege under the law, Professor Wigmore, who is often quoted by as an authority on evidence, points out to a exception to the marital communication privilege. Professor Wigmore mentioned an exception when a transaction in issue was alleged to have been conducted by the wife as an agent of the husband or sometimes by either agent as agents for the other. Therefore, Your Honor, the rule of disqualification or the rule of claiming the privilege is not absolute. Ibig po sabihin, kagalang-galang na presiding officer, ang hinihingi pa lang po ng prosecution ay bigyan po sila ng karapatan na ipatawag ang mga witnesses. Hindi po tatanggalin sa mga witnesses na to ang karapatan nila na huwag mag-testify laban sa kanilang ama kung ito ay ayon sa batas at ayon sa privilege na pwede nila i-claim. Hindi rin po tinatanggal sa asawa ang karapatan na siya'y ma-disqualify to testify against the husband. Your Honor, I also disagree with the ruling of the court that the son-in-law is not qualified because there is a Supreme Court ruling, Lee versus Court of Appeals 625 SCRA 66, wherein the Supreme Court said that the rule applies to direct ascendants or descendants with a family tie connected by a common ancestry. It does not apply to in-laws, Your Honor.